I'm Matt Lauer, along with Savannah Guthrie. We've got some breaking news from the Supreme Court this morning, a decision to challenge part of the Voting Rights Act that could impact the way elections are held all across the nation.
This is probably the most consequential civil rights legislation ever passed in American history. Let's get right to NBC's Justice correspondent Pete Williams outside the court. Pete, what's in this decision?
Well, this decision strikes down a key part of the Voting Rights Act and leaves it up to Congress to try to fix it. Now, there were two parts of the law that were in question here. This is the civil rights law signed by President Johnson in 1965, renewed 4 times, most recently in 2006. It says that states or counties or towns with a history of discrimination must get permission from the federal government in advance before they can make any changes at all in their election procedures. This is the so-called pre-clearance requirement. Well, the court upheld that today, but the court struck down the map, the formula that Congress has repeatedly used over the years to decide who's covered by the Voting Rights Act. Now, this leaves it up to Congress, but the question is, how likely do you think Congress is to do something major like this, to take another look at where discrimination at the polls is a problem, decide who's okay now, who isn't? The Supreme Court signaled 3 years ago that it thought that the Voting Rights Act was out of step with the times. Things have changed in the South, the Supreme Court said then, in an opinion written by Chief Justice John Roberts. And he writes the court's opinion again today. And so the court is clearly leaving it up to Congress. But the question is, can Congress muster the ability to Pete, do what was done? Yeah.
And in the interim, what happens, for example, if a voting law comes up next month? How do they handle it next month?
Well, we'll have to wait and see what the details are here. But there are several requests for pre-clearance still pending with the Justice Department right now that the Justice Department hasn't acted on. We'll probably know here in just a little bit what the details are about what happens now with those pending requests. Some states, for example, New Hampshire, asked to be released from the Voting Rights Act and was. But, you know, you have to think about this. The Voting Rights Act passed in 1965 at the height of civil rights unrest in this country. It was a different climate then that led Congress to decide where the problem existed and where it was no longer a problem. It's going to take a long time for Congress to just do the homework, much less to muster the political ability to get this done.
To say nothing of the fact that, Pete, in the case you mentioned in 2009, the court explicitly asked Congress to rectify these problems with the Voting Rights Act. Congress never acted on that. So I guess the question is whether or not, as you say, they'll have the political will to do anything about it.
That's right. And the court really did send a very strong message to the Congress back then in another case from Texas, while warning to Congress. So in essence, this is a follow-up on the court's original homework assignment to Congress, only this time it's not just a suggestion, it's a ruling striking down the effective part of the Voting Rights Act.
But considering that ruling in 2009 made clear the Voting Rights Act was maybe hanging by a thread, are you surprised that Chief Justice Roberts wrote an opinion that upholds that very controversial section, that pre-clearance section, because that sounds like it remains intact?
Not in the least surprised, Savannah. I would have been, frankly, shocked if the Supreme Court had upheld the Voting Rights Act intact, given its earlier decision and given the way that the oral argument went. It was quite clear that a majority of the court had serious doubts about whether the Voting Rights Act had adapted enough to changing times. And remember what the challengers said here. Not only did they say, look, we've re-elected an African-American president, but we have large numbers, they say, of African-Americans in state legislatures, a growing number in the Congress. However, civil rights groups have said that without this section of the law, that trying to stop the insidious practice of making it harder for minorities to vote becomes a game of whack-a-mole. Now, I will also say this. I know that the Justice Department and the White House were already thinking that this could happen, and they're looking at remedial legislation, something they could ask Congress to pass to try to fix this problem. But it's quite clear what Congress has to do here if they want the Voting Rights Act to come back to life. This section of it, they're going to have to redraw the map.
All right, let's just make sure people understand the ruling from the Supreme Court. One portion of the Voting Rights Act was left intact. Another part, as Pete just mentioned, the map that dictates which areas are covered by this provision of the Voting Rights Act has been struck down.